Thank you, Honorable Mr. Justice Witt. Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Guyana. Judgment delivery in CCJ Civil Appeal GYCV number 8 of 2019 between Kayman Sankar Investments Limited, Kayman Sankar and Company Limited, Benny Sankar against Blairmont Investments Incorporated. This morning's panel comprised their honors, Mr. Justice Witt, presiding judge.
Good morning, Counsel.
And Madam Justice Rajnath Lee.
Good morning, Counsel.
May we have the appearances, please? Thank you.
Good morning, judges. My name is Vidushi Prasad McKinnon, and I'm appearing in association with Mr. Vidyanan Prasad, Senior Counsel, for the applicants.
Good morning, Your Honors. I'm Sanjeev Dattadin, and I appear with Ms. Jamila Ali.
Yes. Good morning, Counsel. I'm happy, Mr. Dattadin, that you succeeded in entering the 21st century.
Just barely, Your Honor. Just barely.
Okay, I will give you a brief synopsis of the decision, which you probably already read, but I have to also say that the third judge, who is not present today, also Justice Jamandar, also signed this judgment. What I now will do is give you a short summary of the judgment, which should not be seen, of course, as the judgment itself that you will find in the official judgment. Court of Appeal in this case granted leave to the respondent to appeal to this court pursuant to Section 6A of the Caribbean Court of Justice Act. The applicants subsequently sought special leave to appeal against that decision of the Court of Appeal to grant leave to appeal on the ground that the respondent was at the material time defunct, a mere name with no legal existence. Later, the respondent filed the notice of appeal, and as a result, the court has now two related cases before it. In the judgment, the court has restated that there can be no special leave to appeal against the Court of Appeal's refusal to grant leave to appeal. Rule 10.12 describes what to do in such a case. A fresh application for special leave to appeal the lower court's substantive decision must be filed, as this is sufficient to allow the court to correct any wrong. Even though the rules are silent with respect to the question, and that is the one before us, whether a party should be permitted to appeal against the decision of the lower court to grant leave to appeal, the principle remains the same. Allowing such an application would cause unnecessary procedural complication and delay. Special leave applications are characteristically fresh applications. Their purpose is to permit this court to do justice where the lower courts made a wrong decision. Special leave, however, must be necessary to achieve that goal. Where the court below has granted leave to a party and a notice of appeal has subsequently been filed in this court, the entire matter is before this court, including a possible argument that the court should not entertain the appeal. And so, no special leave to deal with it is necessary. The special leave application can therefore not be used as a preemptive strike or as a tool to appeal against a lower court's decision to refuse or grant leave to appeal. The court holds that the correct forum at which the applicants must argue what they had argued in this case is the substantive appeal. The application, accordingly, for special leave to appeal is hereby dismissed. The applicants are ordered to pay the respondent's costs on the basic cost scale. That is the decision of the court. That means that the opposite case where Blairmont is the appellant and the applicants are the respondents, that case is now can now really start. What we will do, we will send you in the course of next week a checklist with a plan to deal with that case in the course of the next few months. That is the decision of the court. Is there anything you wish to remark?
No, Your Honor. Thank you very much. Much obliged.
Ms.
No, Your Honor, thank you.
Okay, so thank you very much. As I said, in the
Thank you very much.
In the course of next week, you will get a checklist how we could proceed, and then depending on your answers to that checklist, we will design a track for the other case, which is in fact the same case, to proceed with that. So thank you very much.
Yes.
Thank you very much.
Thank you. Thank you very much.
Thank you.